Our guest speaker today is going to be Gary Van Arnam. Gary is with Northern Trust. Gary, let's see, you have your Ask First form, I believe.
I do.
I don't have a copy. Oh, thank you very much. It says here you got a bachelor's degree. Are you married? I'm just kidding. What's your degree in?
Finance management.
Finance management.
You know, this guy will always throw you a curve. You got to be ready.
Credentials. He has a CFP. Well, we don't. It's a very respected one in the field. We have a former adjunct faculty member. What is the National Graduate Trust School?
That's a 2-year program that I went to back at Northwestern University that helps you to really apply a lot of both technical and practical expertise in the day-to-day management of estates and trusts.
Okay. If you see something that you don't completely understand as to what they did to earn it, ask. Okay, like for example, if you see the certified senior advisor, run for the hills. Okay? It doesn't have a lot of meaning. And there's a lot of designations in this field, not just in the legal field, but especially in the financial services area. So ask if you don't know. This is legitimate. It's actually a 2-year program and you had to work for it, correct?
Oh, yes.
Oh, yes. Okay. You're not... It says here relevant licenses. You don't need a license. Why?
Keep in mind that when you talk about trust companies, we don't sell products. So therefore, I don't have to be licensed to sell products.
You're chartered under the banking regulation here in California. What makes a trust company different in California versus a bank?
Keep this in mind, whether you're talking about a trust company versus a bank or even a brokerage company. Trust companies have a state charter for their trust powers. In addition to being a bank, they usually do have to get the trust powers in order to operate as a trust company. And what that means is that trust companies hold assets in your name. Brokerage and banks have them in their names, and then basically loan them, lend them, do whatever they need. Banks have FDIC, brokerage companies have SIPC insurance. Big distinction here you brought out, Pete, is that if anyone needs all of their assets from the bank, can everybody go in the bank and take out their money at one time? Well, why not? Where's the money? Loaned out. Okay, what about a brokerage company? Can everybody go into their brokerage account and say, I want to withdraw all my securities at one time? No? No? Where are the securities? Loaned out. Again, they can do the same thing. Trust companies have a unique distinction in that we don't show those assets on our balance sheet. Therefore, if somebody comes in and wants to take all of their securities, all of their assets out of the trust company, they can come in and do that anytime they want. We cannot loan or lend their assets out. So in that case, we don't need SIPC or FDIC insurance.
Okay. The other thing as well as for a trust company here in the state of California, there is a requirement to have a reserve. Why would they require Northern Trust to have a reserve and they don't have the same requirement for a bank?
Well, the reserves are really, the reserves are only on the banking side, not on the trust side. Okay.
So I thought they were on the trust side as well. Did
no.
You had to have it. What's the other important distinction between the trust company and the bank? And I'm talking about fiduciary liability.
Okay. Trust companies have to operate at a special standard. And we'll get into this in a little bit. When we're talking about someone who serves as trustee, you're held to a certain fiduciary standard based on your talents and expertise. So if you appoint your if you appoint your brother in order to be your successor trustee, the trustee in that capacity will be judged on what their talents and expertise and knowledge are in the area of being a trustee. Now, let's go ahead and talk about that for a minute. Pete, if I go to hire you as a trustee or as a successor trustee, what sorts of expertise do you advertise that you have, and what sorts of protections do you have?
I do lunch and cocktails really well. I'm sorry.
It's Monday morning.
It's Monday morning. Fiduciary duty takes everything into your background into consideration. So I am held to someone who has the standard of a graduate of law school and someone who has had experience in this area of 20 years.
Okay.
So
if Uncle George makes a mistake, is his expertise or is his level of accountability different from yours?
Yes, he would be held to a prudent person standard. What would somebody who wants to have in someone's best interest that of a prudent person?
Okay, now what if Uncle George makes a mistake? How does he make the trust whole? And what happens if you should ever make your first mistake? What would you do to make a trust whole?
What the uncle does is that he would take money out of his own pocket to make the trust whole. In other words, he would be personally liable. For myself, I would be personally liable for anything that I did outside of whatever is the best interest to the client. What would you do in that circumstances if, heaven forbid, Northern Trust went outside of the scope of a fiduciary duty?
Well, they would say, Northern Trust, we wish you to make the trust whole for whatever breach that they felt we violated. And if we couldn't come to some agreement on what that was, well, we'd probably end up in court. And what the judge is going to say is, Northern Trust, you advertise in the market that you've been doing this for over 120 years, that you have competent people, that you have expertise, you have inside counsel, you have specialists in tax, and all of this experience. You're going to have a tough time saying that you made a mistake that you should have noticed or should have known better than to do. Uncle George, he's going to have a different story. He can go up in front of the judge and go, Judge, you know, I tried my best, but I really wasn't totally aware of all of the implications of being a trustee. And so I acted as a prudent person would act. I did things that were normally prudent. I even hired good people to help me in terms of accounting and legal. But I made an honest mistake. The judge will likely say that according to the standard that Uncle George is being, or Brother George is being held to, that he's not financially liable. Even if he was, maybe Uncle George or Brother George doesn't have the capability to make that trust whole again. So there's a double-edged sword there that you have when you have extra expertise.
What does Northern charge trust for its trustee services?
Our fees depend on the situation. It's kind of an old-fashioned idea about you should get paid according to how much you work. And so, well, basically, we have a published fee schedule, but you sit down and you work it out. You say, well, how much do you really want us to do? How much is someone else going to take care of? What's our investment management? What's our day-to-day operations? And it'll depend. It'll depend on whether it's a business, because we can hold a business, or real estate, or liquid securities. Trust these days, people can create wealth in all sorts of wonderful ways. And so you better be ready as a trustee to handle things such as oil and gas interests, royalties and patents. People may have written books or written music, small businesses. Of course, I said real estate, and that can go a wide variety there. So when you select a trustee, you want somebody who can handle all of those assets, and there'll be different fees that will vary according to that. And primarily for financial assets, it's probably, if you're talking about stocks, bonds, and cash, our fees are probably going to be somewhere around what you normally pay for most mutual funds, except that you've got the added responsibility and liability as a trustee. And again, it depends on the size. Smaller trusts, probably 2 to 3% range. Larger trusts, closer to 1% or maybe even less. Pete, does that match up to what you're thinking in your fees?
Yeah, our fees are approximately 1 to 2% per year, depending on the situation. But you should always ask for the fee schedule, either from a corporate or from a private individual. My ask first form, by the way, is I have it here on the table. Most of you have it. If you don't, please get up afterwards, and if you're interested, I'll have it there. There's a whole group of private licensed fiduciaries in Orange County. Let me just kind of go through how do you get a hold of them. There's a professional fiduciary bureau, and if you go online and just Google it, and if you click on licensee and then only complete Orange County, and it'll give you, click on search, and it'll give you all 40 approximately licensed private fiduciaries here in Orange County that are licensed by the state. What does licensure mean by the state? It means that someone has taken a 2-hour exam. It means that they have submitted to an FBI level 2 security check. And 3, that they have completed the required education. Does that mean that the person once licensed is an absolute professional? I would say not. I would say it would take some experience and some time, but at least it's a beginning. The price ranges for private professional fiduciaries range anywhere from $35 an hour all the way up to $300 an hour, or for a percentage of their fees. In our firm, we have Lisa. You want to raise your hand? Lisa is a private licensed fiduciary. Betty, raise your hand, please. She's a licensed private fiduciary. Laura is going to be a private licensed fiduciary in a little bit. And so what we do, since we're not a corporation, we die. We get sick. We go out and do little silly things. And when we do, then we ask the next individual to step in. One of the things and one of the advantages of having a corporation, having be your successor trustee, is that do corporations die?
Not necessarily.
No, it's very rare. And so if Gary is not in the office, or if Gary gets ill, then there's someone there to take Gary's place and step in on the corporation side. What are some of the other benefits of having a corporation as a trustee?
Well, we're going to have some protections. We're going to have some other services that will work with that. Usually things like financial planning or banking, investments. Those are a lot of expertise that somewhere like Northern can bring to a situation that are usually pretty necessary, pretty helpful.
What makes Northern a little different than Wells Fargo, First American, Bank of America, trust companies?
You're setting me up, aren't you?
No.
Northern, our business has been for 120 years just focusing on helping wealthy people, helping focus just on this. We're not trying to be on every street corner or have a large retail branch. All we do is focus on the needs of wealthy people. Whatever they need, chances are we've got the expertise to help. And that's kind of the thing that works together when you have, there aren't very many simple situations revolving trusts and estates. Everyone has something unique that requires special expertise. So that's always helpful.
Yeah, the thing of it is that remember is that you can choose whomever you want as trustee. If you want a corporate trustee, please interview 1 or 2 or 3 corporate trustees, because they all have different corporate cultures. Just like individuals, we're all a little different as far as individuals, our personalities and how we do things, and that's taken into effect. Corporations have the same kind of culture. Yes?
Let's repeat the question. He said, when you go with Peter, you've got backups, and he's listed several of them. But when you go with a corporate and something happens to the person that you've had the direct relationship, you just kind of thrown into the pot and you get who you get? No, there's a lot of things that may be different between the way Peter and I operate, but there's one thing that's very similar to the way we operate, is that we always place the client first. This is something that whatever goes on, we always work together to put the client first. That means that the personal relationship that we have with an individual, a family, or a group of beneficiaries comes before everything else. Northern Trust will do fine, but it always has to start with what's best for the client. And I can't go through a day when we don't talk about a situation and all of us look at each other and say, what is best for the client? If the client needs to move to Peter, that is purely the decision, is not what's best for Northern. It's best for the client that they should be with a private fiduciary, given whatever the situation might be. If something happens to me and the people come to me or come to the next person and say, I want to interview the person that's going to take over for Gary, and they better get along with that person. They better have some sort of a personal connection. This is more than business. This is a family relationship. And if they come to the point where they say, you know what, after Gary left, I can't seem to find anybody that I'm quite as comfortable with, then it's up to Northern Trust to find the right person, the right place, even if it's outside of Northern, to make that family feel welcome. Trusts these days are portable. That means that you're not stuck with your trustee for life. If somebody comes to me with a trust and it doesn't have much in the way of saying what happens if somebody doesn't like the trustee, I will recommend that they put in a provision that the trustee can be removed with or without cause. Older documents may only say that you can remove the trustee with cause, meaning they made some sort of mistake. But these days, trusts should be portable. Trustees should work for their living day in, day out, and not just because they're stuck there.
Most of you are going to name a family member, okay? So an oldest child, or someone who lives near. The outline today that Gary and I put together is very practical. You can give this to them and they can literally go down the list as to what to do. This is not to try to get you to the corporate trustee or to the private individual, just to understand the circumstances. In serving, you serve as the executor and personal administrator in a will, correct?
Correct.
And you serve as a durable power of attorney as the agent, correct?
Correct.
Do you serve for the Advanced Health Care Directive as the personal representative or the agent?
Let me ask, in the group, what is the Advanced Health Care Directive? What does the person do who's agent for the Advanced Health Care Directive? Does anybody know?
They drink a lot of wine.
Yeah. What do they do?
They have direction, basically, from the individual, which tells them how they want to be treated at end-of-life decisions.
Very much, very much. So surgery, no surgery.
Or they're incapacitated.
Or they're incapacitated. This is somebody that you trust to make very personal decisions. This is someone that you use to either help when you cannot make end-of-life decisions or make treatment decisions, medical treatment decisions. So whether you want certain types of surgery or whether you don't want certain things done in the event that you are in a vegetative state or not deemed to be able to recover. There's some very important personal decisions there. And although we could probably do a good job at it, you don't want a corporation to make that decision. Peter, would you make those decisions?
Yes. Let's pull the plug. Make the job really easy.
Yeah, no. Trouble is, I don't believe that.
And then we have the living trust. You serve as the successor trustee, of course. Do you serve as a trust protector or as a special trustee as well?
Yes, so all those except for the Advanced Healthcare Directive are business-type decisions. How money gets spent, how business is handled, how wills are executed according to their provisions, how trusts are handled according to those provisions. Peter, what's a trust protector?
Trust protector is someone who can hire and fire the trustee.
Okay, what else could a trust protector do?
You could basically review the annual accountings and hire special trustees or remove the trust essentially from the trustee who has it.
Okay, and if you had special types of assets, what could you use a protector for?
Use the special trustee, let's say, for the person has an expertise in paintings. And you could hire that particular individual is the special trustee just to handle all the paintings within a particular estate. So you can name special individuals, you can name a trust protector, you could name a successor trustee. Out of those individuals and all the individuals that we have listed here, that potential roles, do you think your family members that are going to serve ought to be paid? Yes. Everybody agree? Yes. That they should be paid? No. They shouldn't be paid, okay? Well, there is a difference, okay? Now, let's say when you die and the family member takes over your estate, the one individual who is going to handle your stuff as a trustee, do you think the rest of the family think that the person ought to be paid? So please put something in writing with your documents that states my family member ought to be paid, or if you feel that they should not be paid, let them know as well. Does a person that you named in your document, let's say I named Northern Trust, I died. Does Northern Trust have to be and take my case because I have them listed in the document?
No. So that's an important situation. You would want to sit down with the family, particularly the beneficiaries, and say, here's the trust, here's how we would propose to manage this trust, here's the fees we would propose to charge, and make sure that everybody's kind of on board on that. And if you can't come to some sort of agreement, then you need to come up with another option.
Yeah, I would recommend very highly that you allow that the trustee be paid, but make sure the rest of the family knows about it.
Sorry, she asked if the family member, if they're paid, if that's taxable income, and the answer is yes. And that's probably the flexibility that you're talking about, Peter. You could put in there that the family member gets paid, and if the family member is a beneficiary, they may say, gee, if I don't take the payment as a trustee, I'm just going to receive the money anyway, and it would be tax-free versus having to pay income as a trustee. So the trustee can waive collecting the fee, but at least that way they have a bit of an option. But I have seen, you're right, Peter, I have seen situations where the family did not want that family member to be paid whatsoever.
There is no right or wrong in this, but please just express it somewhere in writing so that the person knows whether or not they have the option to be paid or not. If I were to advise someone to say a lay person who has some business sense, I would say not over 1% of the estate value on the date of death. That would be my recommendation. Any difference?
No, but you have to look at it, because if you have a portfolio where you're going to pay an investment manager, let's say you're going to pay them 1%, and they're hiring a CPA to do the taxes and all the accountings, that's another fee. The more that the trustee delegates out to others to do, and the trustee should always hire competent people to help work in areas that they're not sophisticated in, the more they delegate out, the less they probably should get paid. So it depends. You could have real estate management. You could have business management. You have all sorts of things that require expertise that they may or may not be doing themselves.
But just generally 1% or less.
He asked, when you name somebody, particularly either a Peter or a Northern, as your successor trustee, and we're not working during your lifetime, is there any fee? No. The trusts are fully amendable and revocable. You could pull Northern or Peter out of your picture at any time. But what I do recommend, and Peter, this is a good point, I want to hear your point on it, is that if somebody appoints you as successor trustee during their lifetime, what sorts of records do you keep about their trust or their activities or their important personal information?
One of the things that Northern Trust has and that Gary has, and I think you can make it available, is an estate organizer. If you somehow you have an estate organizer, that would be immense benefit for your successor trustee, whomever it is. Do you have one that's available?
Yeah, I do, and I didn't. It's a Word file. If you'll just email me, my email is on the handout. If you'll just email me, it's a Word file. I'll just attach it and send it back to you, and you can fill it out. The handy part about it being a Word file is you can always keep it on your computer and update it. If you want me to send you a hard copy, I'd be happy to do that too. But what I'm saying here is that while you're alive and you've got all this great information about your own situation, don't make it a Sherlock Holmes after you're gone, because your successor trustee is going to need that information, and you think it's so easy. Well, it's in the top drawer of my dresser. Well, nobody knew that that was there. Well, I had 3 safe deposit boxes. Well, who knew to keep looking after they found the first key? So there are a lot of things in your personal life, your funeral arrangements, your advisors. I've even had people give me the whole rundown about how they want the music they wanted in their funeral, the people who weren't invited there. Anything that they wanted to make sure that somebody knew about should go in that organizer. And Peter, you keep this information?
Absolutely. Yeah. Please let the person know who you've named and sit down with them. If you've named somebody as the successor trustee, I'm surprised how many times do you all of a sudden have a letter on your desk saying that you're named and you've never met the individual?
It does happen, but you're hoping it doesn't happen very often. I had one where I went to a gentleman's home and I knew he had 2 cars. I knew he had a Mercedes, and I couldn't find it. And lo and behold, in the top drawer, he had one of the organizers. And I pulled it out, and lo and behold, in Austria, at his second property, there was the Mercedes sitting there at the house. So the organizer is going to really simplify somebody's life.
And you had to go to Australia?
Austria?
Austria?
No, they wouldn't sign off. We hired somebody local. The question was, does Northern Trust handle life insurance trusts? Life insurance trusts are a unique beast because during the life of the insured, not much happens except for the crummy letters, the letters to the beneficiaries, and then a process where the premium payments are made. We can talk separately on this. There are ways to make life insurance trusts more effective. Typically, Northern would step in at the time of the triggering event, at the time the life insurance policy matures. Then we would step in and make sure that it's properly administered and that all the tax... we could. It's sometimes more expensive to have us do it, and we can sometimes come up with ideas that will save you money and not eat up so much during your lifetime. Again,
yes.
This is not about Northern Trust. This is about making the best for the client.
Okay. Will you serve as a co-trustee, Gary, with a private individual?
Peter, some of the best relationships I have is when I'm a co-trustee, when I can balance the Northern expertise, and I can lend that to my co-trustee and say, listen, you don't want to do this, you can do that. We got to be careful to do this. And then on the other side, they're saying, Gary, it wasn't the dad's habit to buy his son a Ferrari. So, you know, it was $100 at Christmas. And so we can balance a lot of what the fiduciary side with the personal side in a co-trustee relationship. They've been worked very well.
I will very rarely serve with a lay person as co-trustee, And the reason for that is that a lay person, I'm going to be just as liable for his or her actions as he or she is with mine. I try to explore the issue. What is the purpose to have co? If the purpose to have co is to keep an eye on me, then I would rather have them serve as the trust protector that they can hire and fire me. It's just that it makes it cumbersome if to have two co-trustees with equal powers, then we have to both agree on everything. And I'd be serving with someone who's an amateur. And it'll be more expensive. There's more potential for conflict. I don't like to do it. Northern Trust does do so. It'd have to be a special situation where I would say a co-trustee. I normally don't recommend it. It's just that we get this idea that being a trustee is a position of honor. It isn't. It's administrative work. Has anybody been a trustee? Is it a position of honor? No.
Did everybody appreciate all the hard work you did?
Yeah. And so, but if we're not there, they think it is, and this is a way to protect. So unless there's a special reason that I think that the co-trustees will work, more than likely I would refuse to take the case.
Well, I think...
Okay. What happens is family members are usually chosen first. And then sometimes they're CPA. If the CPA has never done this kind of work, they're just lousy people to name. Okay? They'll learn it and they'll know it, but they're not going to be doing the nitty-gritty of the work. They'll have someone in their office do the work. It's the same thing if you have a family member. Who does the family member go to upon your death? To your attorney. And the paralegal steps in and helps out, right? So that's usually a lot of times what happens. Who's watching the attorney and the paralegal? Hopefully the beneficiary and the family member. You have a trust company who could serve, and then you have a private fiduciary. Okay, so there's lots of folks involved, if you can, and lots of choices that you could make.